Welcome to Inside IR, a podcast series by Herbert Smith Freehills that explores the latest developments in the Australian industrial relations landscape.
Hello and welcome to Inside IR, the Australian Industrial Relations podcast. This is the series that arms HR and IR and legal professionals with the latest industrial relations thinking. My name is Drew Pearson and I'm a partner in the industrial relations practice here at Herbert Smith Freehills. And joining me today for our latest episode of Inside IR are Shivchand Jhinku.
Hi, Drew.
Hi, Shiv. Welcome. And Patrick Gay from our competition team.
Hi, Drew. Excited to be here and be part of the discussion.
Thanks very much for joining us. It's not our usual episode today. We are going to kind of take things a little bit outside our usual sphere of industrial relations and employee relations into looking at the Australian Government Competition Task Force review into the use of non-competes and non-solicit provisions in employment contracts. Now, these are reforms that the Minister for Competition, Charities and Treasury and the Assistant Minister for Employment has had on his radar for some time. We've obviously seen movement around the world in this space, with the US recently moving to change the position on these clauses in the US. Now, here in Australia, the opportunity for submissions as part of the public consultation closed at the end of May. And once we have the task force have given them a chance to consider those proposals, we expect to see some legislative movements. The proposed reforms appear to be a natural progression from the recent closing the loophole amendments, and they're intrinsically linked to the concept of employee mobility, promoting the freedom of movement of workers. The underlying assumption here is that employees should have the liberty to move and choose where they are to be employed, and providing those greater freedoms that we've seen throughout the closing the loopholes reforms. This could have profound impacts for employers and employees, reshaping contractual arrangements and potentially altering the dynamics of the Australian job market. So that's enough from me. Let's jump in and explore what these changes could mean. Now, Shu, this is an area that you often work in, the restraint of trade space. Why do we have non-compete and non-solicits in employment contracts, and where are they commonly found?
Good question, Drew, and we don't have that long for me to take you through the entire history going back to the 1800s for the case law, but what we have are two really broad types. We have non-competes and non-solicit, sometimes called no-poach clauses, and those ones are typically used to protect a company's confidential and proprietary information by preventing former employees from working with a competing business or from poaching clients, customers, suppliers or other employees for a period of time after their employment has ended. Now, just to throw some stats at you, according to the Australian Bureau of Statistics, 1 in 5 workers in Australia has a non-compete clause in their contract. 50% of workers have some form of restraint clause, and 21% of all businesses use non-compete clauses. Now, I've been talking about employment contracts, but importantly, we can see these types of provisions included more broadly. So particularly where we have a sale of business that occurs, there are typically clauses that are included in those agreements also to operate to protect the buyer from the actions of the departing individual. Now, why do we have them? On one hand, the argument is that these non-competes and non-solicits are necessary to protect businesses from unfair competition and prevent employees from using the information and knowledge that they have gained to obtain an unfair advantage after their employment ends. Those non-compete restraints can also be used as an incentive for companies to invest in their employees' training and development because they can do that on the basis that that knowledge won't be used elsewhere for a period of time. Now, on the other hand, there are some that argue that those non-compete restraints actually lead to lower wage growth as employees are unable to move quickly to higher waged salary places or working for competitors, and that means that they have fewer job opportunities because they can feel locked out of a particular industry because of where they have been working. Across the Australian states and territories, these provisions are typically unenforceable, so that's the starting position we come at it from, unless they are reasonably necessary to protect the employer's legitimate business interests. So there are already quite strict limitations on how they operate and how they will be enforced. So typically we see the courts, where they do get involved in these in dealing with these clauses, is where we have employers who've had access to confidential information or have significant client connections. So courts have long held in Australia and in overseas that there is a legitimate need for these non-competes and non-solicits, and often they're probably the only way that businesses can really protect those interests from having a lot of knowledge and a lot of information walk out the door when employees leave.
Sure. And so, Shu, is the Competition Task Force only considering non-competes in this review?
No, interestingly, it's not. It's much broader, and this is something I think Patrick will also want to weigh in on. But it looks at non-solicits, non-poaching, non-disclosure agreements, and wage-fixing agreements. So it's quite a broad remit. Now, we do see some of those in employment contracts, but more broadly, I think we see broader arrangements that will apply across the contractual arrangements that organisations have.
Great. And now, Patrick, I mentioned at the outset that there's been a bit of movement. This is not unique to Australia, is it?
No, of course not. I mean, non-competes are not unique to Australia by any stretch of the imagination. They're prevalent in both other common law jurisdictions, such as the UK and the US, but are also in civil jurisdictions as well. And it's been interesting to see how things are developing and changes which are afoot in those jurisdictions. I mean, one of the things we'll talk about this later is that what has been increasingly happening when you look overseas and potentially about to happen here is a change of the focus of non-competes and particularly non-poach arrangements and also price fixing or wage fixing arrangements, not as really just matters of employment law and industrial relations law, but increasingly matters to be potentially of a concern of competition law. Mm-hmm. So when you look at the UK, for example, they did a legislative review a few years ago. The government said that they were going to introduce legislation which would introduce time limits on non-competes. That didn't come to pass. And as we know, there is an election coming up in the UK. So it's certainly not going to happen in the next couple of weeks. But I think, interestingly, the CMA, which is the Competition and Markets Authority, which is the main UK competition law enforcer and regulator, issued a paper earlier this year and has kind of reinvigorated the debate in the UK around non-competes. In the US, federal jurisdiction, there are distinctions. So many states, for example, including California, have effectively put limits or bans on non-compete clauses for some time. What we've had, most interestingly, again, in April of this year, the Federal Trade Commission, which again is a competition law regulator, announced a rule banning non-competes except for senior executives. The FTC concluded effectively that non-competes contravened relevant competition law legislation in the US. Now we're going to see what happens around that. The rule was propagated, but immediately which is the way in the US, there have been a number of lawsuits already filed asserting lack of constitutional authority or regulatory authority. So that's a bit of an open question, what will happen in the US.
And I mean, it's an interesting point. We do see with these macro trends that they do make their way around the world. We've seen it with the right to disconnect. 10 years ago, we were talking to our colleagues in Europe and they were telling us about the right to disconnect and we thought that they were all crazy. But fast forward and we now have a variant on it here. Shu, what do you think we're going to see post this task force? report?
Well, that's really interesting because, as Patrick was saying, if you look at the UK experience, there was a lot of work that was done and there was a lot of change that was going to happen, and that hasn't really taken place. Whereas you look at the US experience and the European experience, where there has been different attempts and different ways in which they are regulating this space. So I think here the Australian government, given its focus on wanting to improve wage outcomes for individuals in different ways without necessarily just increasing those wages themselves, I think we will see some regulation here. Mm-hmm. And there are a couple of different ways I think that could happen. So what we could see is a legislative response which requires compensation to be paid. So if a person is subject to a non-compete, then they are required to be paid an amount, whether that's their base salary or a percentage of it, as a way that ameliorates the difficulties of not being able to work during that period. Secondly, we could see, as Patrick mentioned, there could be a threshold which applies. So whether that's the senior individual or some sort of income threshold. So for example, the high income threshold seems to be an easy one that might be adopted in this space as a marker to say if you are above or below, that then impacts on whether or not you have a restraint or how long that restraint applies for. And thirdly, we could see a legislated period of time. So it could be the government simply says that restraints can be no longer than a specific specified amount. So those options are definitely on the cards, and so we could see those being implemented. What I don't think we will see is an outright ban on the use of these clauses, but that we certainly can't rule that out.
Yeah. And Patrick, I know from previous discussions we've had, the competition law deals very narrowly with employment law matters under the Competition and Consumer Act, and there's a specific carve out. There's a section of the issues paper issued by the Competition Task Force regarding broader competition issues. Can you share a little bit about that?
Yeah, certainly. So, I mean, it is a little bit unusual, the context in Australia and the limits on the competition law. So there is a somewhat confusingly and somewhat untested provision in the Competition and Consumer Act, which effectively provides a broad carve out in respect of matters relating to a contract of service. So essentially in respect of employment contracts, employment terms, and so forth. Interestingly, that carve out doesn't apply in respect of independent contractor contracts, etc. So you have this carve out in the Act. And the issue paper, in addition to bringing up issues around sort of employee non-competes, also talks more broadly about non-solicitation clauses, non-poach clauses, and also wage fixing arrangements. And so they talk about sort of non-solicitation or non-poach as sort of coming up in two types of contexts. One might say a bare sort of agreement where two competitors or two people who aren't directly related to each other just say, we're going to agree with each other that we won't poach each other's employees. And that may happen from time to time. And then there's other sort of times where that is more likely to occur when there might be ongoing joint venture relationships or interactions between employees within a kind of broader commercial context. And the parties might agree as part of those arrangements, you're going to be exposed to my employees, the other person is going to be exposed to the other employees. We're agreeing while those arrangements are on foot that we won't poach each other. So we've got those sort of non-poach arrangements. And then we have wage arrangements where effectively the issues paper is saying, well, there may be circumstances where simply one business agrees with another business. There's going to be a cap. We're not going to pay people anything more around those sorts of things. And I think what's interesting is when you look at the sort of competition law, and if you say, if that was an agreement between businesses not setting the price of wages, but effectively setting the price of other goods or services, that would be a cartel provision under the terms of the competition law and would be per se illegal, subject to various exceptions. And we were talking about there may be exceptions in respect of the purchasing of goodwill and so forth in a sales arrangement. So you have something which is a little bit perhaps unusual, that you could see sort of analogous situations in respect of goods or services which are potentially criminal contraventions of the Competition Consumer Act, but there's this carve out in the law. And I think what's happening here is that when you look at other agreements, and the approach which has been taken in the EC and so forth is that a wage fixing agreement would be per se illegal under the kind of competition law provision. So we'll not see what's happening here in this jurisdiction. So what we have here is potentially something which could be analyzed under a kind of a competition law matrix, but at least at the moment, the carve out prevents that from happening. I mean, there's some ambiguity in the Act, but the fact of the matter is the ACCC hasn't taken the same kind of cases which it's taken, competition authorities in Europe and other jurisdictions have taken on similar facts. And that is because of the carve out that is in the Competition and Consumer Act.
So picking up on that, do you think we're headed towards a situation where the ACCC will have a broader interest in employment-related matters?
Well, I think they definitely will. I mean, the first thing is we're talking about a report of, the Treasury looking at these things, and their ACCC staff is seconded to that Treasury task force. So they've got a direct interest in that. I think, as we will all know, the ACCC is a sort of a regulatory body in which the government, for various reasons, wants to sort of push more responsibilities and expansion in. There obviously has been this sort of change, but I think when you look at it from an ACCC's perspective, they are keen around reform. And I think you might say that the Australian law, with this sort of carve out and not applying the competition law matrix to this kind of employment situation, is a little bit out of step with what's happening in other jurisdictions. So I don't think it'll be surprising to me that the ACCC is kind of part of this process, and we'll have to see how it pans out. We'll be sort of thinking, well, maybe we should revisit this exception, and we should be having some enforcement authority in respect of these types of agreements. It's a bit of wait and see, but I think that's definitely on the cards.
Okay. Well, Shu, Pat, it's been great to have this chat. What do you think the big ticket items are here? Are there things that employers should be starting to think about? What's the key takeaway?
Well, I think, from my perspective as a competition lawyer, we'll see what legislation changes. But I guess I would say, I wouldn't be recommending to anyone listening to this podcast to get the feeling to say, oh, well, a wage fixing arrangement is fine, or these things are definitely fine. The law is ambiguous. And I think if you're thinking about doing those sorts of things, even at the moment, you should be getting proper legal advice before you make a decision to do any of those sorts of things. But change is afoot. I think that's my takeaway.
Terrific. And Shu?
Yeah, I agree with Patrick in terms of there is going to be change here. And in order to be able to deal with that, I think people need to know what base they are starting from. So on that basis, I think now is a good time to be looking at what the contractual arrangements that people have in place for their employees and how they protect confidential information at the moment. Is it limited to particular people? Is it password protected? All of those things which are good business practice, which should be looked at again with a fresh lens, and not just looking at your contractual documentation and the words on the page, really thinking about how people engage with their customers and their clients. Do they have more than one point of contact for their key clients, so that you don't have that key person risk if an individual leaves? That's not a legal solution, that's a business solution, and those are the things that people need to be thinking about, and perhaps having one eye towards what other options are there if non-competes and non-solicits are removed or severely curtailed. How are businesses going to be able to deal with that? And that may be looking at things like extended notice periods, garden leave, those sorts of things, and just being aware of the protections that they have under the Corporations Act. But for the moment, probably not a great need to go out and make wholesale changes, but to be aware and start thinking about this space, because I think change is coming.
Yeah. couldn't possibly disagree with that. This is one of a number of changes that are facing Australian employers at the moment. So as we draw this episode to a close, it's extremely clear that the reforms have the potential to have far-reaching implications when we find out what they actually are, and then obviously see how industry and the regulator responds from the potential legislative changes to the strategies that employers should consider. We've covered a lot of ground. We've also looked at how those reforms might draw from earlier rounds of reforms or proposed reforms, as the case may be, in the US and the UK. And of course, it's always the devil is in the detail as these reforms make their way through. As always, we value to hear your feedback from our listeners, and we'd love to hear your thoughts on this episode, as well as any topics that you might like us to cover in future episodes. You can comment or direct message us on LinkedIn or email us at insideir@hsf.com. Thanks to you, Pat, for joining us today, and Shu for your insights, and we look forward to bringing you another episode of Inside IR in the near future.